Well, okay, we start to consider resolving a personal injury case. The first thing is when the client has completed their medical treatment. And this is, again, there's always another way to look at things, and I'm going to get to that in just a moment. But for the most part, for most cases, most injuries where the client has made a complete resolution of their accident-related injuries, we want to wait until they're done. We want to wait until they finish with the doctor. All of the therapy has been completed. They're back to work. They're back to doing their normal daily activities. They're back participating in sports or whatever they were doing beforehand. And the reason we wait is because, well, think about it. If you're finishing with your doctor in December, but I start to try and resolve your case in November, and we resolve it, then it's not going to include all the things that go on in December. It's not going to include the medical bills that you incur in December. It's not going to include the suffering, the inconvenience, the aggravation, the disruption of your life, the time that you might have had to take off of work to go to those last 3 or 4 or 5 or 6 therapy sessions. So we wait. We wait until everything is done. And then we can look back and we can, as the expression goes, then we can write the book and tell the insurance company what happened. We can do that completely. Now, there's a caveat, and that caveat is that sometimes we have to also pay attention, well, we always have to pay attention to what is called the statute of limitations. The statute of limitations varies from state to state. In Virginia, it's 2 years. In Maryland and Washington, D.C., it's 3 years, which means you have from the date of the occurrence of the injury, the date the accident occurred, the date the collision occurred, you have from that date 2 years in Virginia, 3 in Maryland and Virginia, in which to do one of two things. You have to either settle the case with the other party or their insurance company, or you have to file a lawsuit to protect the statute from barring your case. Because if you wait one more day, in Virginia, if you wait 2 years and 1 day, and you have not settled the case, and then on the first day after the second year is over from the date of the accident, if you wait to that extra day, and then you go file the lawsuit, eventually there's going to be a motion to dismiss the case, which the court is going to have to agree with, and the case is out. It's gone. You have no recourse. No matter how bad the injury, no matter how egregious the conduct or the action of the other party in causing you the injury, you get zero, nada, nothing, zippo. And the reason for this, the public policy reason, is that we want to have individuals be accountable for what they do, but we can't make them accountable for their whole life. We can't follow them around 35, 40 years later and say that you did this to me way back then. So all of the states have invoked statutes of limitations for injury type of claims. They run from 1 year, I've seen as much as 5 years in some places, I believe 4 years maybe. I don't know all of them by heart, but depending upon where you live, you can just go into, say, the internet, Google search or MSN or Yahoo search, and type in the catchword statute of limitations, comma, and your state, and you'll be able to find it instantly. There has to be a deadline, and that's what the caveat is. So in a normal case, we wait until clients have finished with their medical treatment. In a case where the medical treatment continues and it's going on and there's significant problems, we have to file that lawsuit before the end of the deadline to make sure that their rights are not lost.